Good evening, ladies and gentlemen. Good evening, good evening. Welcome to our 7th Constitutional Revival class. I know it doesn't feel like we're now at the 7th one. It seems like we just started, and every 2 weeks we've been doing them, but tonight is number 7. I want to again thank, of course, Joanne Woodard and David Hagar, without whom none of this would be possible, and all of you who have contributed. And right now we have paid for the webinar, so right now you don't need to send any more checks. I got another one this week, but for now we're good, and you don't need to send any more checks for now. So thank you for your contributions, or we wouldn't be online and on the air. David's company is called Beyond Innovative Technologies and Consulting, and he keeps us going straight, without which I would never be able to do this, and we wouldn't be able to have this. Anyone wishing to review the material, please go to my YouTube channel, which is Constitutional Revival with Royal Alexander. And of course, we are also on Facebook. So we are going to start. And also, if you ever have questions, you can send an email to constitution.royalalexander@gmail.com. Constitution.royalalexander@gmail.com. But tonight is the 7th class, and we're going to do the Second Amendment. We finished the First Amendment before in a spirited conclusion, all the great rights in the First Amendment. Tonight, we're going to turn to the Second Amendment. And I always say with great respect that on the eighth day, the Lord God made the Second Amendment. And I mean that with great respect to the Lord and to our God. That is how important the Second Amendment is to the freedom of America, which means the ability of America to reflect strength, power, and safety, light to the rest of the world. That's how important the Second Amendment is. I always say that the framers put the Second Amendment in there in case they forget about all the rest of them. The Second Amendment is in there in case they forget about all the rest of them. A review of history makes clear that people who are armed are much more difficult to subjugate and to destroy than people who are armed. When we are without weapons, we are totally at the mercy of a government. And people sometimes say, you know, Royal, sometimes you're a little melodramatic about all that. I don't think so. Look at 2020. And when I say look at 2020, I mean look at the year 2020. Look at what we have been through in this country. Look at the lawlessness. Look at the efforts to defund the police and the rest of the insanity. Look at it. I don't think it's overstating it at all to say how critically important the Second Amendment is. Keep in mind this, criminals often think things through, and if I want to commit crimes, if I want to commit murder or rob or do a home invasion and steal and harm people, I want to go do it in a neighborhood that's a gun-free neighborhood. I want to go in those homes and commit my crimes where I know I won't be shot. The worst thing that happened to me is maybe I'll be hit by a bat or a golf club or get stabbed, but I won't be shot. And of course, I'm going to be armed as the robber, as the criminal. So if anyone comes at me with a bat or a golf club, I'm going to shoot them. That's why when you want to do your crimes, you always want to go to the gun-free zones, because you're saying in big, bright letters, come and steal from me. Come and harm me and my family. We're not protected. We're not protected. So I say some of that tongue-in-cheek, but not really, not really. Well, look at the couple in St. Louis. Again, that mob was coming up the street a few months ago. The couple in St. Louis, coming up the street, the man stood out there with an AR-15 and his wife with a little pistol in her hand, telling them they were coming directly toward their yard. Don't come on my property, don't come on my property. Because the world is insane and upside down right now, the prosecutor in St. Louis said, I'm charging them, not the rioters and looters and the people who were trespassing. Let's leave the criminals alone. Let's go after the law-abiding gun owners who were there protecting their property and their homes and themselves. Let's be sure and go after the law-abiding people. That's how insane things are in this country in 2020. All we need to know and remember is when all law and order breaks down, Again, we've seen it again. Human nature doesn't change. I know the Constitution is 243 years old, but human nature is thousands of years old. It doesn't change. So the fact that the Constitution is 243 years old doesn't matter. The same considerations, the same human nature that led our framers to brilliantly put in the Second Amendment to protect citizens, individuals, is still as applicable today as it was the day the Constitution was ratified. So don't let anyone tell you the Constitution's outdated. The hell it is. It's as relevant today as it ever was. And if we needed a concrete example, 2020, the year 2020, has given us plenty of concrete examples. When defund the police takes over and the police don't come when you dial 911, the Second Amendment is there. When defund the police becomes all about politics, which it has in this country, and when politics takes over, which it always does, because by human nature, people want power. When that happens, and we are completely vulnerable as citizens, the Second Amendment is there. Even doing their best, and I compliment the large majority of excellent law enforcement officers, even doing their best, though, on their best day, the police can't arrive immediately, no matter how hard they try. And death, violence, and harm can come to us and our families in the meantime. But until the police arrive, the Second Amendment is there. I had a friend tell me recently, Royal, I hope these people know that when they've successfully defunded the police, and the only thing standing, and there's nothing standing between me and my family and my property and these rioters and looters and violence seekers, when that day comes, I hope these people understand I don't have any rubber bullets. All mine are steel. I don't have any rubber bullets. When there's nothing between me and the people who want to do my family harm and me harm and damage my property, I don't have any rubber bullets. They're all steel. I thought that was a rather sobering way of putting it. When we are alone in our homes at night, the Second Amendment is there. It's a statistical fact that criminals commit less crime after they have been shot. It's also a fact that guns don't kill people, people kill people. And I want to share something with you, an article. Some of you may have read it and may remember it, some of you may not. It is a beautiful way of stating this. He writes to the editor, Walter Digger, in New Shady Cove, Oregon. Mr. Digger writes, "My gun," that's the entitle, to the editor. "Today, I swung my front door wide open and placed my Remington 870 right in the doorway. I gave it 4 shells and left it alone and went about my business. While I was gone, the mail gal delivered my mail. The trash man picked up the trash. A girl walked her dog down the street, and quite a few of my neighbors drove by. Well, after about an hour, I checked on the gun. It was still sitting there, right where I had left it. It hadn't killed anyone, even with the numerous opportunities it had. It hadn't even loaded itself. The shells were still on the side." Well, Mr. Editor, you can imagine my surprise with all the media hype about how dangerous guns are and how they kill people. Either the media is wrong and it is the misuse of guns by criminals that kill people, or I have one of the laziest shotguns ever made. I must hurry off now and check on my spoons, because I hear my spoons are making people fat. Again, Walter Digger, New Shady Cove, Oregon. What a brilliant way of stating his shotgun and the shells, just sat there. And not only did the shotgun not shoot anyone all that time he was gone, the gun didn't even load itself. That is a great characterization of how it's not the gun, the weapon that's doing the killing, it is the person holding it. So when people, I think they're idiots, make statements like, you don't need an AR-15 to go deer hunting, I always respond, well, it's not the deer that I'm worried about attacking me. I'm not worried about the deer. The point is that the sacred, intrinsic, unalienable rights that we possess, they don't ever go away, even when government breaks down and we return to the law of the jungle. Again, we've seen a little bit of the law of the jungle this year. We are still possessed, no matter what, by the mere circumstance of our birth. We are still possessed with an intrinsic worth, value, and dignity. And we have a right and an obligation to preserve our lives and our families and defend ourselves. So that is why the Second Amendment is there. Those are some comments I want to frame this up with. And now we're going to talk about the text of it itself, the Second Amendment itself. A well-regulated militia, and this is, I'm quoting the text of the Second Amendment. So if you have your Constitution with you, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, we're about to break that short sentence down. But before we do, I want to say it again to you. The Second Amendment, its very text, a well-regulated militia being necessary to the security of a free state. Listen to those words. A well-regulated militia, and we're going to talk about militias in a minute, being necessary to the security of a free state, comma, the right of the people, not an army, the people, the right of the people to keep and bear arms shall not be infringed. I want to start out by saying, in the time of the founders, the militia were the normal, everyday, common people. That was the militia. That's why they shocked the British, because the British couldn't have ever expected them to be able to fight. Fortunately, Washington whipped them into shape. This is the militia. They had to be trained up, many of them, in how to even use a musket. The militia were the common people. So when the left tries to say, oh no, it's the militia means the army, they're the only ones, or the police, they're the only ones who are supposed to have a gun. Wrong, wrong. The militia was the common people. The militia was the citizens. Keep in mind, the principal debate surrounding the Second Amendment has been whether the right to use and buy guns, weapons, belongs to individuals or only to a militia. Starting in 2008, and the Supreme Court case in 2008, Heller versus the District of Columbia. Heller as in it's going to hell in a handbasket. H-E-L-L-E-R versus the District of Columbia. In two cases, the Supreme Court, in some of the most beautiful writing, and I think constitutional law, even when I disagree with it, some of the very best writing there is in the area of constitutional law. It's brilliant writing. In 2008, in two cases, the Supreme Court accepted the view that Americans have the right to arm themselves for personal use in their home. And they applied that right to federal, state, and local laws. And thank God they did, because there's a bunch of crazy blue states that would like to strip their state of every weapon but that owned by police. And once again, if you want to commit your crimes, you're going to a gun-free state or a gun-free neighborhood or city. So I won't get shot while I steal, or while I rape someone in your family, or while I kill you. I don't want to be shot while I'm committing my crimes, so I'm going to a gun-free zone. Thank God the Supreme Court said that right, the personal, individual right to keep and bear arms, applies to federal, state, and local laws. The courts have permitted, it bugs me, but the courts have permitted government to limit some rights of gun manufacturers, owners, and sellers. Gun manufacturers, owners, and sellers. Now keep in mind the debate about whether the mentally handicapped should be able, or incapacitated, mentally incapacitated, should be able to own firearms or purchase a firearm. Whether a felon should be able, after the crime, even after they're finished, should be able to possess a firearm. I don't mind felons not being able to possess firearms. I think you sacrifice some of your rights when you violate our law. That felon has already broken some criminal laws. Therefore, he has infringed, transgressed upon someone or somewhere, some property or some person's constitutional rights. Well, I think by violating someone's constitutional rights, that felon should have to sacrifice a constitutional right and not be able to have a firearm. But just keep in mind, there are some, no rule, no right is absolute, none. Even in the First Amendment, we saw that. But the Second Amendment is a strong one, and it says that, applying it to federal, state, and local laws, that it is a personal right, not a collective right. It's a collective right also, because that's where the police and our military and other law enforcement come into it. That's the collective right. But I'm talking about our personal right. In your home, in your vehicle, you get to be prepared to defend yourself. And again, all the laws are going to apply to you if you shoot your gun recklessly, if you make a poor decision, but at least you're armed and can protect yourself. And then it's just up to your training and your good judgment about how much force to use. But at least you're in a position to defend yourself and your family. That is a hugely important principle in this country, in this Constitution, and it was in the minds of the framers. Absolutely. The early American history makes that clear, and when people try to say otherwise, I just kind of smile to myself thinking they don't know early American history. Now, as I said, the courts have permitted manufacturers, owners, and sellers to be limited somewhat. Today, questions, and you have heard a lot of this, and I'm reminding you, today, questions about the Second Amendment center on bans on assault weapons. Again, Roy, you don't need an AR-15 to go deer hunting. And I love to tell them, I'm not worried about the deer attacking me. I'm worried about a criminal attacking me, or a group of criminals, or a gang. Has anybody heard of MS-13? A ruthless gang. Their calling card is beheading people with machetes. They're armed also with weapons, but the calling card is cutting the head off of their enemy. Do you think people want to be armed? I'm not worried about the deer attacking me. I'm worried about MS-13 attacking me. I'm worried about the Bloods and the Crips attacking me. I'm worried about a home invasion. I'm worried about a group of people coming down my street, and maybe my handgun is not enough. I'm not worried about the deer. Not worried about the ducks or the geese or the dove. I'm worried about criminals. And you got to always remind people of that. So bans on assault weapons, mandatory background checks, waiting periods, and other restrictions on gun sales or use. You've heard all of it. Every year there's the argument about the ban on the assault weapons, about mandatory background checks, about waiting periods to purchase a gun, and other restrictions in different states. Some states will restrict guns as far as they possibly can till they bump up against what the Supreme Court has said in the Heller decision and another recent similar Supreme Court case. Some states, as I said, would like to entirely restrict guns from their state. Thank God the framers put the Second Amendment in there, and that the Second Amendment has been applied through the 14th Amendment to the states. And directly also, the Supreme Court has also said that right applies directly to federal, state, and local governments as well. We get to keep and bear arms with those limits I have mentioned. Now, I want to get into some constitutional analysis, what I call statutory construction, but here it's constitutional construction. I want to get into the analysis. Let's look at the text of the words in the Second Amendment. Look at what the Supreme Court said in 2007 when it held about what that clause means. And again, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. We're about to tear those words apart. Listen to how the majority in Heller decided that the right of the people was an individual right, not a collective right, like the militia. Again, the militia were the common people. It's like saying the framers, I think they just thought we weren't going to be stupid. Sure, they wrote in that formal language often, which makes it somewhat a little more difficult, but they were learned men, they were learned people. But this is pretty clear. The right of the people to keep and bear arms shall not be infringed. And I want to explain something to you about the word infringed. Infringed means the right already existed even before the Constitution was written or ratified. That's important. Our Constitution creates out of, well, not out of the air, out of our intrinsic rights as human beings. It creates a bunch of rights, our Constitution does. But every now and then, it merely says, this one pre-existed the Constitution, and you can't infringe it. Keep in mind what the word infringe means. It didn't say the right of the people to keep and bear arms is hereby created. It doesn't say that. It says, shall not be infringed. Well, you can't infringe something that doesn't exist. So scholars read that to mean, and the Supreme Court clearly did, the right to keep and bear arms pre-existed the Constitution, which makes perfect sense if you know anything about early American history. Those men, look what they had to go to break away from Great Britain in the first place. Look at the American Revolution. You think they're going to rely on a document to give them that most fundamental right to be free, which stems from the right to defend themselves and protect their families and demand their freedom, which you do with a firearm. So keep that in mind. Now, we're about to tear the language apart. The right of the people, and again, I want you to be proud of yourself. It's just like right now, you're in law school, okay? We're tearing apart a passage right now, like we would if you were in constitutional law, in a classroom in law school. So how are we going to define the right of the people? Here we go. The right of the people to keep and bear arms. Okay, the operative clause. The first salient feature of the operative clause, right of the people, is that it codifies a right of the people. The unamended Constitution and the Bill of Rights, keep in mind, this is a classic way of interpreting a statute or the Constitution. You look and see how things were used, terms used throughout the rest of the document. So the Heller court is going to look and see how the term right of the people, because that's what we're tearing apart. Keep in mind, the right of the people, the right of the people. So the Supreme Court, it's a classic, again, case of using statutory canons of interpretation. Here, canons of constitutional interpretation. When it's a federal statute, that's canons of statutory construction, those statutory canons. Here, these are constitutional canons of interpretation. The first, the right of the people. Listen to this. The unamended Constitution and the Bill of Rights uses the phrase, quote, right of the people, close quote, two other times. In the First Amendment, assembly and petition clause, keep in mind, right of the people. We've been over the First Amendment, so it uses right of the people there. And in the Fourth Amendment's search and seizure clause, the right of the people to be free from unreasonable searches and seizures. We're going to get to the Fourth Amendment, maybe a little bit tonight, maybe not, but we're going to get to it. Look what the court's doing. Let's look and see where the phrase right of the people, right of the people. We are tearing the words apart to get to their meaning as the framers intended, not some moving, living, dynamic organism entity that changes. You know, this year I feel this way, next year I'm gonna feel this way if I'm on the Supreme Court, so I'm gonna say it means this next year. No, what did the framers mean by those words? Not what do you mean by, which is again why there's absolutely no right to abortion in the 14th Amendment of the Due Process Clause, the Liberty Clause of the 14th Amendment. It's not in there. It's made up. Not in there. So we don't get to just make things up. Here, the court is saying in the Second Amendment, what is the right of the people? And they're looking about how the framers used the phrase right of the people in other places in the Constitution. They used it in the First Amendment. They used it in the Fourth Amendment. They go on to say the Ninth Amendment uses very similar technology. Very similar terminology. Listen to what the Ninth Amendment, we're going to get to it too down the road. Here's the Ninth Amendment, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. By the people, see, we got by the people again. Up in the Second Amendment, we have a right of the people. In the Ninth, we have by the people. In the First, we have the people. Remember, it's the right of the people peaceably to assemble. You see, the court very intelligently doing constitutional interpretation is using these tools. And one of them is looking at how the very same phrase was used throughout the rest of the body of the Constitution for an indication, for insight into what the drafters of it meant in the Second Amendment. I mean, it's a brilliant way of doing it. All three, back to the court. So First, Fourth, Ninth. It's got something referring to the people. With the people, of the people, the people. All three of these instances, the court says, I'm back to Heller, the Heller court, unambiguously refer. All three of these examples, we're trying to interpret the right of the people here in the Second Amendment. We've looked at the First, the Fourth, and the Ninth. In all three of those instances, First, Fourth, and Ninth, those instances unambiguously refer to the individual right, not a collective right. So the court is extrapolating from that, saying, because they meant it as an individual right in the First, Fourth, and Ninth, we're going to assume they meant it as an individual right in the Second. See what I'm saying? See how they're doing it? It's a brilliant way. It's being faithful to the text of the Constitution. We've talked about textualism and originalism. What the court's doing now is both. It's looking at the text of these words of the people, for the people, to determine originally. That's what originalism is. Textualism, we're looking at the text of the words. Originalism, at the time the Constitution was drafted. What did the framers mean at the time the Constitution was drafted? Well, to figure out what the framers meant at the time the Constitution was drafted, we need to go look at other parts of the Constitution to see if those phrases were used similarly. And the Heller court says they were. Again, all three of these instances, and we're doing straight up constitutional interpretation. I want you to know, I know I'm going slowly through this because I want you to understand how the court interprets, in this case, the Constitution. It's similar to how it interprets statutes, or let me say, how it is supposed to by the text, textualism, or based on original meaning, originalism. Okay. Again, this Heller court says all three of these instances, First, Fourth, and Ninth, unambiguously refer to individual rights, not collective rights. Meaning, in those three other areas of the Constitution, they're talking about a right of the people, you, the individual. Don't try to make it seem like, oh no, it's a collective right. They're just talking about the army or the militia or the police, because that would be the collective right. We allow them to be armed to protect us. No. We're talking about an individual right. And we know that because the court, this is just, you don't get this in every Supreme Court opinion, even in the area of constitutional law. They're tearing it apart word by word, which at the end makes the analysis and the holding so much stronger. That's why we're going through it. Okay. Going on with the Heller Court, there's still, look how every word matters. This is why it matters. This is why whenever you're analyzing something, I want you to think about what the Heller Court was doing and the things I'm emphasizing. 3 provisions of the Constitution refer to, quote unquote, the people in a context other than rights, the Heller Court is saying. What about the most famous preamble? We the people of the United States, in order to form a more perfect union. You know the rest of it. That's the first one, we the people. Article 1 provides that the people will choose members of the House. And on and on. We've already been through those articles. But look how the Heller Court is looking at where the people is used throughout the Constitution. To see each time the framers, the drafters, those 56 men in that hot room in Philadelphia where they stayed 5 or 6 months, they didn't have the windows open, they didn't have the doors open. It was miserable. You know, they didn't have air conditioning. You know the kind of clothes they wore. Must have been miserably hot in there. They had to keep the doors and windows closed because they weren't supposed to be in there writing a constitution. They were supposed to be in there revising the Articles of Confederation. So it was miserable. The big states didn't trust the small states. The delegates from the big states didn't trust the delegates from the small states. And the delegates from the small states sure didn't trust the delegates from the big states. George Washington sat there all those months. He didn't really contribute anything substantive from a standpoint of constitutional law. He contributed his moral authority, sitting in that room, because people like Benjamin Franklin thought, you know what, it's not going to get too out of hand if George Washington, the most esteemed, most honored figure in our new country, or this country we're trying to form, is sitting here with us. It's only going to get so crazy. It got raucous at times, but George Washington sitting there. So I know I'm digressing, but I want you to see what I mean. The Heller Court is looking at other things. He says, we the people, then the people will choose the House. The 10th Amendment, the mighty 10th. Those rights not explicitly granted to the federal government, meaning enumerated powers, are reserved to the states and to what? The people. You see how the Heller Court is looking for every place where the drafters created rights for the people to see in each instance. Were the drafters creating a collective right to create a militia, the police, or the military, or were they intending to grant an individual right to be possessed by each one of us? So we're tearing it apart. Again, the Second Amendment, the Heller Court. They said, look at this. The 10th Amendment says, providing those powers not given the federal government remain with the states or the people, the people. Those provisions, here's the Heller Court again. Those provisions arguably refer to, quote unquote, the people acting collectively there, but they deal with the exercise of reservations of rights, not power. That's true. The 10th Amendment is about power. Those powers not expressly granted to the federal government are reserved to the states and to the people. That's intended to be a collective right. That's power. In that sense, you can't personally possess power. You can personally possess rights, but power exists from a standpoint of being able to enforce our rights and vindicate them and protect them. Now, I'm not trying to get too in the weeds with you here, but the court's going through. So they're saying the 10th really is not an example of the individual right, because we're just saying those powers not given the federal government are reserved to the states and to the people, power. But listen how they keep going. However, nowhere else in the Constitution, this is important. This is a very important sentence. Again, the Supreme Court in Heller has gone through and analyzed the other places where we're talking about the people to see what the framers meant. Now listen to this sentence. Nowhere else in the Constitution does a quote unquote right attributed to quote unquote the people refer to anything other than an individual right. You see the analysis they've done? And we're not done, but I want you to know, Hank, stay with me on where we are. The Heller Court, Heller versus the District of Columbia, deciding that we always knew the Second Amendment was a collective right. The question always was, which was never framed up until this case, was whether it was also an individual personal right to keep and bear arms. And we're seeing the Heller court tear apart, closely analyze a whole bunch of the rest of the Constitution to see when this phrase is used by the drafters, the people, do they mean it to mean literally the people, you, me, our family, my brother, my sister, your family, individuals, or do they mean it to mean the police and the military? Do you see how the Supreme Court is looking throughout the document to see how to define what the people means? An individual right or a collective? Okay. This is the conclusion so far. Nowhere else, and they know this is going to be scrutinized so hard because so many states, so many people want to have no guns. Thank God in heaven for the Second Amendment and a court that will protect it. Anyway, here's the sentence again. After looking at all those amendments we just went through, some we haven't gotten to yet in our class, but we're going to. Nowhere else in the Constitution does a right attributed, a right, quote unquote, a right attributed to, quote unquote, the people, a right attributed to the people, refer to anything else, because they went and looked. We just went over that. Anything else other than an individual right. Please keep these thoughts in your mind. What is more, I mean, this is just a great opinion. It's great not only because of the Second Amendment, it's great to learn how to tear a statute or the Constitution apart, how you really analyze. And this is what good judges are supposed to do. This is what Judge Amy Coney Barrett has done on the Federal Appeals Court and what she thinks ought to be done now. It's called the strict constructionism we talked about, which again, textualism and originalism. Not this judicial activism, which says, you know what? Let me tell you what judicial activism is here. Oh, this right only pertains, we don't need to look at the whole rest of the Constitution in painstaking detail to learn what the words the people refer to. Good judging is hard work. What we're doing is hard work, but this is how we get to where we get to. Judge Amy Coney Barrett thinks, you know, you can't just read the words, a well-regulated militia and stop. Oh, they just mean a militia, the Army, law enforcement, a collective right. That's all they mean. She thinks you need to read the whole rest of it, including, as these judges are doing, these justices are doing in Heller, looking at the whole rest of the document to see what the people means throughout the rest of the Constitution, because typically drafters are going to use certain phrases in a certain way every time. That happens so much, and it's a great tool to use to try to interpret what they meant here when they used the phrase the people. When they said the people in every other amendment in the Constitution or in the Articles, which we've already been through, they're doing that here. They said the members of the House are going to elect the House of Representatives, the people. That has to be individuals. I mean, I'm the only one who can go vote for the House of Representatives. They're canvassing. No, they're doing a hell of a lot more than canvassing. They are scrutinizing the whole rest of the Constitution. Now, what is more, listen to this, please. In all 6 other provisions, they went and looked throughout the whole document. These are excellent law clerks for these justices, the ones in the majority. What is more, in all 6 other provisions of the Constitution that mention, unquote, the people, the term unambiguously refers to all members of the political community, not an unspecified subset, like the police, like the military. Again, what is more, I'm quoting straight from the Heller case. What is more, in all 6 other provisions of the Constitution that mention, quote unquote, the people, the term unambiguously refers to all members of the political community. That means individuals, all members, not to an unspecified subset, like the police or like the military, the Army. So still looking at the meaning of the operative clause. Again, this is how you do it. The right of the people. That's the operative clause. If you're going to figure out whether this is an individual right or a collective right, what is the operative clause? The right of the people. The right of the people. Putting all of these textual elements, and again, this is great writing. Here's the court again. Putting all of these textual see text? Text means words. Textual elements together. We find that they guarantee the individual right to possess and carry weapons. I mean, you can't do it better. Short of having Benjamin Franklin or Madison or any of the other signers, Gouverneur Morris, or on and on and on. Short of having those men to ask personally, James Madison, what did you mean? Did you mean for this to be a collective right? Just for the militia, just for the army? Or did you mean for it to be an individual right? Of course, he already wrote enough. And then with the Federalist Papers further explaining things, they meant it as an individual right. But the court is it's going through the paces. The Supreme Court in Heller is doing the hard work. Again, putting all of these textual elements together, we find they guarantee the quote unquote individual right to possess and carry weapons. You can't break it down. No one's making things up out of thin air, as happens in the case of judicial activism. You know what? I think we just ought to stop about the militia. That's enough. They put the militia, it's one of the first few words. A well-regulated militia, comma. That's the first few words of the Second Amendment. That should be enough. I think what they meant is just for it to be the army or the police, not people, individuals. That's judicial activism. It's actually intellectual laziness. It's intellectual dishonesty. Those people are all very bright. It's intellectual dishonesty. To not go any further. Well-regulated militia, yeah, that's all they meant. No, it's not all they meant. Here's the court, putting all these textual elements together, bouncing around the Constitution to see how the people is used. All of it together, we find they guarantee the individual right to possess and carry weapons. The court goes on. This meaning is strongly confirmed by the historical background of the Second Amendment. We look to this because it has always been widely understood that the Second Amendment, like the First and the Fourth Amendment, codified a pre-existing right. Again, this is an important concept. I said it in the beginning. Amendments like the Second and like the First and because keep in mind what the First says. Congress shall make no law, we're at the First Amendment, just a quick bounce back. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. You can't prohibit the free exercise of religion if the free exercise of religion does not already exist. It already existed before the Constitution. Back to the Second Amendment. So did the Second Amendment. This is such brilliant analysis. I mean, this is how you weave together. It's great. It's great constitutional interpretation. It's great writing. We look to this, which is the historical background of the Second Amendment, because it has always been widely understood that the Second Amendment, like the First and the Fourth, people don't need to be free from unreasonable searches and seizures if they don't already have those rights that exist for them to be infringed upon with an unreasonable search and seizure. You see what I'm saying? These rights have to already exist to need to be protected from the government trespassing upon them. These rights aren't giving you the right to these privacy in your home, in your individual papers and other things already exist. You have the right to not be walking down, before the Constitution, you had the right to be walking down one of the villages, one of the colonies, and not have some magistrate throw you over and knock you down. Having your individual rights trampled with no probable cause. Even then, before the Constitution, you couldn't do that. So these rights, including the Second Amendment, codified, meaning put into, not a statute, into the Constitution, a pre-existing right. The Second Amendment, tell me if this does not make sense to you. I know it does. My God, these men had been through the American Revolution. Long before there was a Constitution, these men had fought and died, risked everything to free our country from Great Britain. You think they didn't think, by virtue of my being alive and with the inherent intrinsic dignity I possess as a human being, a piece of that dignity is being able to defend myself with a weapon. You think they didn't know that when they were writing this Constitution? Hell yes, they knew that. Pardon. Absolutely, they knew that. It was a pre-existing right. The very text of the Second Amendment implicitly recognizes the pre-existence of the right and declares only, quote, that it shall not be infringed, close quote. Again, you can't infringe something that doesn't already exist. So the right to keep and bear arms individually pre-existed the Constitution. Why? Because the very text of the Second Amendment implicitly recognizes the pre-existence of the right and declares only that it shall not be infringed, close quote. That's good stuff. That's the heart of it. That is the heart of the Second Amendment. That, in my view, always existed, but it was never as framed up as well as it has been by the Heller Court. We shouldn't have to sit on the edge of our seats, which is why we worry so much about the United States Supreme Court. Because those 9 justices, since Marbury versus Madison, it is emphatically the duty and province of this court to say of the judicial department to say what the law is. That's that famous sentence in Marbury versus Madison. Many people say it's the most famous sentence of all in the Constitution because it gave to the courts, the federal courts, the Supreme Court, judicial review. And judicial review is the right to oversee everything the Congress does, everything the states do. It is emphatically the duty and province of the judicial department to say what the law is. Marbury versus Madison. We should have to sit on the edge of our seats to know that the plain common meaning of voice is the plain common meaning. But a brilliant way of doing it is looking at how the same phrase is used throughout the rest of the Constitution. Because presumably, and there's a strong presumption there, these men, Madison had worked on this for months before the Constitutional Convention so that they could go directly to the heart of each of these matters, each of these amendments, each of these rights, each of these fundamental rights. But thank God for the Heller Court, because there's members of the United States Supreme Court, just less than a majority, who don't agree with this at all. They want to give states far greater power. They want to give Congress far greater power to limit the individual right to keep and bear arms. So that is the deal about the Second Amendment. It's a brilliant holding. It's brilliantly written, and I commend it to you for your consideration. That is the Second Amendment. All right. The Third Amendment, we're just going to pivot. There's really not much relevant for our purposes to the Third Amendment. It simply says, but imagine the times they were living in for the Third Amendment to even need to be written. The Third Amendment, no soldier shall, comma, in time of peace, comma, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Obviously, that's in there in the form of a constitutional amendment because they had seen this very situation abused. I try to explain to people, those framers, I do know this. The document is divinely ordained. These thoughts to put all together at one time over a 5-month period, men, there's some very brilliant people, but men are not able to do that. I think, without some divine inspiration. But I want you to know that inspiration was on top of these men's experience. These framers, the signers of the drafters of the Constitution, had lived all of these experiences. That's why they wanted it to be an individual right to keep and bear arms, because they had been unarmed. They knew they wouldn't be free without their sorry old weapons somehow defeating. And again, Great Britain never fully committed its forces, or it would have crushed America. We didn't fully defeat Great Britain. My God, Great Britain was in wars all over the globe, but the parts of it that were sent to the United States to battle got defeated, thankfully. What I mean is, those drafters knew all of these things. Why did they not want a religion established by the state? That's the Establishment Clause. Why did they demand free exercise of religion? Because they didn't want to have to be forced to participate in a state religion established by the state. These men lived these things individually. So back quickly to the Third Amendment. It's just about quartering troops, but clearly they had seen it abused, which is why it's an amendment, the Third Amendment. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So if they have to be quartered in a time of law, it can't be unlawful. It can't be illegal. There has to be some statute in place saying how troops, when they can be quartered, when people can be forced to take them in. Is it for the protection of our new country? Say you live on one of the coasts and you have a home, and say American troops are getting ready to repel an invader coming in on, say, the California coast, and you have a home along the California coast, and some of the Marine Corps needs to stay in your home for a few days while they're preparing to fight the enemy that's coming in. Well, if that's going to happen, there has to be federal statutes governing that, and there are, of war. But that's the Third Amendment. It wouldn't be in here but for the fact that the framers had a negative experience with the quartering of troops in people's homes. So no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in any time of war, but in a manner prescribed by law, meaning you can't do it even then unless there's a law allowing it. In that example I gave of, for example, keeping the Marine Corps. If you live along the coast of California, someone's coming to invade us in boats or airplanes. If they need to stay in your home for a while, there's a federal statute allowing them. You just got to let the Marine Corps stay in your home. Of course, if you want to remain free, I would be happy to have the Marine Corps staying, members of the Corps staying in my home. And I think you would feel that way too. All right, as usual, the time blew by. Let me just touch on what I'm going to finish next time, which is the Fourth Amendment. So we did finish the second. Right to keep and bear arms shall not be infringed is an individual right. The third, can't quarter troops in people's homes without the owner's consent. And even in war, it has to be outlined in a statute, the conditions upon which they can be quartered. And now the Fourth Amendment. I'm just going to start because I just realized 7 minutes till 7 o'clock. But I go at this pace because I want you to understand this stuff. It's not easy thinking. I used to leave my classes in law school after constitutional law. Well, I probably left them feeling most of my classes this way, besides constitutional law, but certainly in constitutional law. I would almost always leave with a headache because, it's a professional school, so it's intense. You're going to get called on probably. You may have to stand with 75 other people in your classroom. The professor calls your name, Mr. Alexander. Please stand and recite the facts or the indicia or the language of the First Amendment, the Second Amendment. What does freedom of speech mean? What does free exercise mean? What does the Fourth Amendment mean? There are classes in law schools devoted just to the Fourth Amendment. Well, what we're doing is hard work. It takes real, undistracted, focused thinking. But if you do it, you will discipline yourself and you will begin to think this way. This is what it means to think like a lawyer. Here's the text of the Fourth Amendment. The right of the people to be secure. And again, we just talked about the right of the people in the Second Amendment. Remember, the court looked up here at the Fourth to say, does the people and Fourth Amendment mean individually? Of course it does. The whole clause wouldn't make sense if it weren't individually, because you can't have your right to privacy collectively infringed. The only way I can have my right to privacy, I'm sitting in my house right now. I live on a street in Shreveport, Erie Street. It's all quiet right now. But if for some reason several Shreveport police officers ran up on my porch, knocked my door down, came in here, knocked me to the floor, and arrested me, they better have a warrant. That's the first thing. But secondly, it is my expectation of privacy sitting in my home individually that is being invaded, that is being infringed, that's being violated. So you see, the people, like in the Second Amendment, could only mean royal individually, because the only way to invade my right to privacy in the Fourth Amendment is to come knock me on the floor, knock my front door down, and not have a warrant. Because, brother, if they don't, they're getting so sued in federal court under Section 1983, because they will have been acting under color of law in a way that deprived me of my constitutional rights, one of which is to sit in my home alone and without a warrant for coming in here. They have no probable cause to be here. Fourth Amendment, 4 minutes. The right of the people, individual, just like the second, the court, Heller Court looked at in the second, the fourth here, the right of the people, individual, to be secure in their persons, houses, papers, meaning my documents, my work, maybe my legal documents I draft, and effects, all my other stuff. The word effects covers lots of things that I own, against unreasonable searches and seizures. Unreasonable searches and seizures. Again, there is whole law school courses taught about the Fourth Amendment alone. Unreasonable searches and seizures shall not be violated alone, shall not be violated. And no warrants shall issue. They better not come knock my door down here on my street while I'm sitting here without a warrant and probable cause that I've done something that justifies them knocking my door down and arresting me, that I'm running the drug trade out of my house, that I'm selling illegal. Well, I mean, there's 1,000 things illegally I could be doing. They better have a warrant that lists as the probable cause to come on my porch, knock my front door down, knock me on the ground, and arrest me. They better have probable cause that I'm doing something illegal. Shall not be violated. No warrant shall issue, but upon probable cause, supported by an oath or affirmation. These police officers, the FBI, they better have sworn, and they have to, on the affidavit seeking the judge to sign the warrant. They have to swear they believe Royal Alexander is selling illegal drugs out of his house, or he's, counterfeiting money. Back in my back room, I'm counterfeiting money. They better write counterfeiting money on the arrest warrant. They better swear we have probable cause to believe he's counterfeiting money at his house before they can do it. Supported by an oath or affirmation. They have to swear they believe I'm doing that, counterfeiting money. And particularly describing the place to be searched, 611 Erie, that's my address. If they get that wrong and they go to my neighbor's house and they knock her front door down, and there's cases just like this, and they knock her on the ground, brother, they're getting sued. They're at the wrong house, can't be at the wrong house. Probable cause doesn't extend to my next door neighbor, it only pertains to me. The place to be searched and the persons or things to be seized. They can only come in my house looking for a counterfeiting machine. They don't get to go look for a bunch of other things in a bunch of other closets if it's not in the warrant. Now, we're 1 minute from 7. We're going to keep going on the Fourth Amendment. Maybe read it before we quit tonight, so in 2 weeks it will be refreshed. I'm going to do it real quick again. The right of the people to be secure in their persons, houses, papers, and effects, with an E, against unreasonable searches and seizures. And we're going to tear that apart next time. Shall not be violated. And no warrants shall issue upon probable cause. They better know I'm selling cocaine here. They better know I'm counterfeiting money here. That's the probable cause, supported by an oath or affirmation by the law enforcement officer saying, Judge, please sign this warrant, Judge, because Mr. Alexander is counterfeiting money at his house. Do you swear? The judge will ask him, do you swear you have reason to believe he's doing it? And the judge may ask him, well, what reason do you have to believe? He's counterfeiting money. Because if you're wrong, you know you're getting sued. Oh, no. We have informant. We have other things. We've observed strange things happening around his house. We have probable cause, Judge. Please sign the warrant. The judge signs it, but it better particularly describe the place to be searched. 611 Erie. They go to either of my neighbor's house and knock their door down and throw them on the ground. They're getting sued. And the persons or things to be seized. They better write counterfeiting machine down. Don't go look in my closets. Maybe I have an illegal pistol in my closet. You don't get to go look in my cabinet. You don't get to look in my armoire. You don't get to look under my bed. You get to look for any machine I'm using to counterfeit money, and that's all. And now, if the warrant's much broader than that, of course, then they get to look out the whole house. Don't let me not also say that. But it's about the warrant. It better say it in there, because they get, and if they come and find things beyond what they had a constitutional right to be looking for, beyond the scope of the warrant, then if I'm their defense attorney, I'm going to file what's called a motion in limine, a motion to suppress the illegal evidence. And I think I'm going to win, because I'm going to say, Judge, they never had any right to go look under my client's bed to see whether it's cocaine under the bed. They don't get to look under the bed. So whatever they saw under the bed gets suppressed. It's illegal. They only had a right to come in my house under our facts here, because they said on the warrant, he's counterfeiting illegal. He's counterfeiting dollars. He's in the counterfeiting business. That's all you can go do. Go look in the attic for counterfeit stuff. Do I have a counterfeiting machine in my back house? Where do you get to look? And when they go outside those lines, those illegal searches get to be attacked in court. They get attacked all the time, and evidence gets suppressed all the time under the Fourth Amendment. All right. That is tonight. We did the second, we did the third, and we have laid a foundation for the fourth. I encourage you to go and read the Fourth Amendment, look at each word individually, each word, and think to yourself, look at what the Heller Court did, because it can apply throughout anything we do in this class. The Heller Court looked and said, what does we, the people mean throughout the Constitution? And here we see in the Fourth Amendment again, the right of the people to be secure in their persons, houses, papers, and effects. All right, guys. Let me see if there's any questions. It's 7 o'clock. It's actually 7:03. Let me see if I got any questions. All right. Here's one. Mr. Alexander, why does it seem like police, when they stop people in their cars on the street, get to virtually do whatever they want? Thank you, Nashville. Thank you, Tennessee. Why does it seem like the police get to do whatever they want on the side of the road? I'm going to address this again in the next session when we dig into and through the Fourth Amendment. What is the expectation of privacy? And I should have said this during the class now. What is the reasonable expectation of privacy? And y'all don't let me forget it next time. What is the Fourth Amendment is all about, what me and any other reasonable person, what expectation I have of my privacy. The greatest expectation any of us have of our privacy is in our homes. Okay? We still have privacy in our front yards. It's just not as great as in our home. We have far less privacy when I go out to the street, because the street is public property. When I get in my car, which I own, the protection picks back up, but the Fourth Amendment protection in my vehicle is not nearly as great as it is in my home. So I'm driving down the street. Keep in mind, and again, if this is true anywhere in all of constitutional law, it is true in the Fourth Amendment. It is so fact specific. Each case is slightly different. Each stop by a police officer on the side of the road could be different. And so the way the police officer responds could be different. there's the zone of privacy. As long as a police officer knows the individual in the car, he can look in the car around where someone may be able to reach for a weapon, the length of their arm. But that doesn't mean they get to go search the whole rest of the car and the trunk without probable cause. So here's a classic example. Nashville, Tennessee. If someone is driving down Line Avenue in Shreveport and they get pulled over, a police officer doesn't get to pull them over just because they pulled out of one of our popular bars here, say Superior Bar and Grill. Just because someone pulled out of there and may have been drinking, that doesn't give probable cause. Or they're driving a beautiful red, fast-looking sports car. Or the top's down. Maybe it's a group of girls. Their hair's blowing in the wind. They look like they're having a great time in a fast red Corvette. None of that gives probable cause. They're pulling out of Superior Bar and Grill. They may have been drinking margaritas, but they may not have. You don't get to go on a fishing expedition. So they're in the car. Clearly, they're pulling out of the parking lot at Superior Bar and Grill. 3 girls, candy apple red Corvette. Looks like the music's cranked. Their hair is blowing. Looks like they're having a great time. No reason to stop them. Now, if the driver, that's a fast car, if she punches the accelerator and say the speed limit on Line Avenue is 40, this is highly technical and ticky-tack, but let's say she goes 41. She's now broken the speed limit. That's a violation, and that gives probable cause to at least, for a police officer, pull that car over. Now look how the step goes, and I'm gonna, just please don't let me forget to do the step again in 2 weeks. Look how this incrementally builds. I'm sitting across the street from Superior. I see these girls pull out, candy apple red Corvette. They take a ride on Line Avenue and start coming down the street. Looks like they're having a blast. They're driving in their lane. Keep in mind, if they were to drift, and again, that's also very ticky-tack, because I don't know about you, but we can drive stone sober. And if you're looking down or looking in your console or looking at the radio, you can easily go toward the center line and touch it. Legally, you're supposed to stay right in the center line. So that's very ticky-tack, but still, if she swerves a whole lane over and then gets back, a cop could stop her because she's supposed to stay in her own lane, and that's a violation. She swerved into another lane. Even if it's a quick little, not some big crazy like drunken swirl, I'm just talking about a little swerve. That theoretically, technically, a police officer has a chance to pull her over. She's now going 41 miles an hour. The speed limit's 40 on Line Avenue. Or she never signaled and she just swerved over. I forget to say it. She swerved and didn't signal and goes back. That's a violation. You're supposed to signal before you move to another lane. These are very basic driving rules that we learn when we got our driver's licenses. Police officers use these kind of things all the time. So look, she's speeding. Let's say she guns it and she's not going 41. Let's say she's really speeding. Let's say she's going 50. Just punches it, having a great time, radio's cranked, and boom, 50 till she goes to the red light up at Piermont and Line Avenue. She's clearly speeding. She gets to be pulled over. A cop pulls her over. He gets to come up to the car and say, ma'am, I'd like to see your driver's license and registration. He may ask her, could you step out of the car, ma'am? All of that is officers are allowed to do for their safety. So let's assume she steps out of the car, gets the registration and her driver's license, hands it. Well, now the police officer's maybe 2 or 3 feet from her, and the smell of alcohol may come to his nose. That now increases the probable cause, and he gets to ask her, because of the smell. If he didn't smell the smell, he's got to stop with her driver's license, registration. Ma'am, I'm going to write you a speeding ticket. You were speeding. Why were you going so fast? I'm sorry, officer. None of us drink. We were just out having a good time, and I just punched it. Okay, well, I'm going to write you a speeding ticket. You got to slow down in through here. But it is because he didn't have an additional grounds for probable cause. But being able to stop her for speeding, being allowed to get her out of the car with her license and registration, he now gets to be in her body space. And he smells alcohol. That then allows him to say, ma'am, have you been drinking? Because he's been alerted. That increases the strength of his probable cause. And she gets to either say, yes, I have, or no, I haven't. Well, If she says, no, I haven't, but he smells it, he's going to say, well, would you submit to a breathalyzer test? She says no, and he says, well, ma'am, you don't, and this is important, you don't have to submit to any of those tests on the side of the road. Keep in mind, I didn't mean to get off into DWI tonight, but while we're here, you don't have to submit to anything. You can say, officer, I'm not going to participate in any test. I don't have anything to say. Respectfully, I just want to talk to my attorney. Cop's probably going to say, well, you're going to be arrested. We're taking you downtown. I understand that. Just get arrested. That's going to be for about 5 to 7 minutes. You're going to be taken downtown. And if you have a good attorney like me, you're going to be bailed out. Then when your case comes up in 30 or 60 days and you haven't taken the breathalyzer and you haven't done the walk-in turn or the horizontal gaze nystagmus, this thing, or the walk-in turn, they're not going to have any, you didn't take the breathalyzer. So the only evidence is going to be, well, I smelled an odor of alcohol. Well, there's things other than alcohol that smell like alcohol. You know, rubbing alcohol. If I have a long, hard day weightlifting or running and my neck hurts, you can put isopropyl rubbing alcohol. Some of those other liniments and other ointments and things have smells that smell like a wintergreen smell, like it could be alcohol. So that's not enough. Now, back off that. I didn't mean to get into DWI law. Just remember, you don't have to submit to anything. Just respectfully say, officer, I'm not going to participate in any tests. I don't have anything else to say. I'd just like to talk to my lawyer. He said, well, we're going downtown. You're going to be arrested. Boom. You'll be there in 5 to 7 minutes. They'll book you. Then you'll be bailed out. And then I'm going to hammer that case. But that's probable cause going down the road. So that's a long-winded way of saying that on the side of the road is where the police have their greatest power. But when we get to court is where I have my greatest power. So on the side of the road, you're kind of at their mercy. And in a way, it would have to be that way. If cops weren't in control, I mean, but all that gets to be challenged in court. So just stay cool. But that's when you pull out of a very popular drinking establishment and go down the street in a candy apple red Corvette with the windows down, radio cranked, hair blowing, that does not give probable cause until she has a tail light out, or until she's speeding, or until it's ticky-tack, she swerves into another lane without signaling. I think most of us do that every day. We just cross lanes over when no one's around. You're really supposed to slow down. That gives probable cause to pull her over, and then the police officer gets to be within the space of the driver, which can have additional probable cause. So it's a lot of little details, but the next answer was just kind of, the next question was just like that, similar to that. The next question is, do police always have to have a warrant to come into my home? Just about yes, except if there are exigent circumstances, like that knock and announce. Boom, boom, Shreveport police, we're coming in, boom. That's knock and announce. But they better have probable cause that, say, drugs are being flushed down the commode, or that a criminal, or you know, a suspect is running away. And if you waited on a warrant, the drugs would be destroyed and the suspect would have run away and be gone. A lot of this is a fine line. I want you to know a lot of this is a fine line. But there's also something called the plain view doctrine. And keep this in mind, the plain view doctrine. I have a front door and a back door, and I don't have curtains on them. If, for example, I was working at my front table and it looked like I was bagging cocaine, or if maybe it looked like I had a marijuana plant growing in my house, the police officer has a right to stand on my sidewalk. He can't come on my property, but he has a right to stand on my sidewalk and look in my front door, because anyone in America could stand on my sidewalk or on my street and look in my front door. That's called the plain view doctrine. If a police officer sees that, a marijuana plant, that gives him probable cause without a warrant to come on in right then. Or what looks like cocaine. Now, it better not be baking soda, because if it's baking soda, he's in trouble. But there's so many pieces to the puzzle in the Fourth Amendment. What is a search? That's a whole line of cases. What is a seizure? is just being on the side of the road being talked to. A lot of people feel like I can't leave if the cop's talking to me, but unless you're under arrest, you can leave. But it's called a custodial interrogation, but the person's still free to walk away. All of those details. When you say, well, what about this? I would have to say, I need to know all the facts. It's really a puzzle in the Fourth Amendment. I got to know certain things. Anyway, what I want you to understand is the general gist of the Fourth Amendment, which we're going to keep going through, but that's when they can come in without a warrant. If you give them probable cause from the street, he's bagging cocaine on his front porch. As I say, I better not be in the business of baking soda and putting it in little baggies, which I'm going to sell to high schoolers who need it to brush their teeth when they go off to camp. Baking soda can be used to brush your teeth. Oh, if they get that wrong, they're getting sued. Or if they see what looks clearly to be a marijuana plant. That's called the plain view doctrine. The plain view doctrine applies to cars, to vehicles also. So look, that is where we are tonight. That was the last question. Please consider rereading before you go to bed the Fourth Amendment, just so it's all fresh. And we will pick back up in 2 weeks. Thanks so much for being here.